Hi, folks. Next up on This Week in Law, we've got an amazing panel for you today with Professor Susan Crawford from the Cardozo School of Law and Art Neal from New Media Rights. We're going to talk about SpongeBob on your gravestone, amazing resources out there available for users and creators, net neutrality, and the latest lawsuits that will determine the open internet rules, copyright reform, and a really cute new little geek in the world. All next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CacheFly at CACHEFLY.com.
This is Twill, This Week in Law with Denise Howell, episode 233, recorded October 25, 2013. Pallante, Funkadelic. Hi, folks. I'm Denise Howell, and you've joined us for This Week in Law. I'm so excited that you're here with us today because we've got a really phenomenal show. When I started doing this show 7 years ago, there were certain people, I figured it would be a good idea to do this show because it would be a good way to get in touch with, have contact with, intelligent conversation with certain people out there that I'd always admired and heard about and really idolized as far as being thought leaders relating to law and policy of the internet. And we have one of them here with us today. That is Professor Susan Crawford from the Cardozo Law School. Professor Crawford does so many things. She is co-director of the Berkman Center at Harvard, for one thing. She works with the city of New York on their innovation and technology issues. And I'm sure, her reputation precedes her, and the people who listen to this show are probably well aware of who she is, and we're thrilled to have her with us. Thank you so much for joining us, Professor Crawford.
Gosh, Denise, that's quite an introduction. Thank you very much. I'm delighted to be here.
It's wonderful to have you. Also joining us from New Media Rights is Art Neal, the founder of New Media Rights. Art, I sort of think of New Media Rights as an EFF kind of organization on a smaller scale. Do you want to fill us in? Am I right about that? How do you compare to and contrast with EFF?
Sure, that's fair enough. We actually work with the EFF quite a bit. We worked with them on the anti-circumvention provisions last year. But I would say that the difference is, well, the EFF has many times the size our staff. We're really complementary to organizations like EFF and Public Knowledge and others, because what we're doing is really we're in the trenches working with folks one-to-one, day-to-day. That's really our bread and butter, is working with individual creators and entrepreneurs who require specialized internet, media, and communications law expertise. And so we're a nonprofit program. We're independently funded. We're part of California Western School of Law, and we provide free and low-cost services to a variety of folks who need specialized internet law expertise. We're probably best known for working on a lot of content bullying issues, but mostly we provide preventative and transactional services, which does make us a bit unique. I mean, we're really trying to keep people out of needing lawyers, frankly, keep them out of the courtroom and keep them creating and keep them innovating. And so we also take what we learn from those individual creators and we turn it into just hundreds of video and written guides on our website. And then we also take what we learn and we go to policymakers and we try to help make better law. And so in those cases, we do work with folks like at the EFF and friends at Public Knowledge and elsewhere to try to bring perspectives of independent creators and entrepreneurs who just simply aren't at the table very often.
Professor Crawford, I mentioned our show just turned 7 this last week, I think October 22nd. Of 2006 is when we did our first episode. And I noticed that something that is near and dear to your heart also just turned 7, and that is One Web Day. Can you tell us a bit about that?
Yeah, and One Web Day was my idea to launch an Earth Day for the internet, a time when people would be more self-conscious about their relationship to the internet and their responsibility to ensure that it remains a diverse, open, healthy, thriving place. One Web Day is always September 22nd every year, And yes, this is the 7th year. It's celebrated in many different ways in many different countries.
And this year it was all about accessibility. Is that correct?
That's right. When I went into the Obama administration, I had to back off from direct involvement with One Web Day. And the terrific people at the Internet Association took on a lot of the thematic management. And this year's accessibility, making sure that more people have access to the Internet.
A very worthy cause. So if you're not already observing One Web Day, do check it out. Add it to your calendar on September 22nd. Nice complement to Earth Day in April.
That's right. That was the idea.
Yes. Let us start looking at some cases and policy considerations that are in the hopper right now. We talk a lot on this show when it comes up about net neutrality, and Verizon has just had its day in court last month in its case against the FCC, challenging the open internet rules that the FCC enacted. Verizon has a number of arguments that it is asserting that the DC Circuit is considering and will be doing so for quite some time before it issues an opinion in the case. Professor Crawford, let us know what's at stake here, and if you can, kind of ballpark where you think the court will go.
Well, the big story here is that the FCC completely deregulated high-speed internet access about 10 years ago, and yet is still trying to sort of regulate with one hand. And Verizon is pointing out that it's unclear what the FCC's statutory authority is over high-speed internet access because they deregulated the whole thing. And so Verizon's claim is that the open internet rules are sort of like common carriage, like what you would have required a telephone company to do in the earlier part of the 20th century. They've got some pretty powerful legal arguments, and it did seem that the DC Circuit was favorably inclined. It was really having trouble, really frustrated by the FCC's legal gymnastics at this point. That the reason this case is so important is that if the FCC ends up having absolutely no authority over high-speed internet access, that throws the whole issue up. Everything about consumer protection, competition authority, lots of protective steps the FCC could be taking to keep the internet open will now be subject to nothing but the vagaries of the marketplace. And the FCC will have to decide what to do. It could, if it loses this case, simply administratively relabel high-speed internet access as a regulated service. And I very much hope they will take that step. Another very important aspect of this case is that Verizon is claiming very broadly that it's a First Amendment speaker, just like the New York Times, and that it reserves the right to edit internet access at any time for any purpose. This claim took up several pages in their brief, and it is really unlimited in its consequences, because if this is true, and if the court doesn't knock down this First Amendment claim by Verizon, it means that Congress will have no authority to say anything about telecommunications access in America, which would be a terrible state of affairs.
So Verizon is analogizing itself not just to newspapers, but also broadcast entities in its First Amendment status. Is that correct?
No, it really wants to say we're just like a newspaper. So they're going all the way to saying there should be no limits on what we're able to do as editors of internet access. I think too few people are aware of this argument and its stunning consequences for internet access in America. Verizon said during the argument that they would like to be charging at both ends of their connection, charging other networks for connecting to their network. And they're, we believe, already doing this by systematically constraining access to networks used by companies like Verizon, for example, as well as do a lot of price discrimination on the user side through usage-based billing and all kinds of special bundle deals for users. All of this cuts gravely against the economic growth and possibilities for creativity that an open internet make possible.
So if Verizon wins, the internet that you get, if you are a Verizon customer, is going to look very different than the internet that you get if you are a customer of, say, Time Warner or some other more independent provider. Is that correct?
No, this is actually much broader than that. If Verizon wins, then the FCC has nothing to say to any provider of high-speed internet access. There are really no limits on the scope of Verizon's argument. It wouldn't just bind Verizon itself. And so what we'd be getting is much more like a cable system where the provider picks and chooses channels and decides how much to charge for them, and we're just left to their whim.
All right. So every individual internet would look different then. If you're a Time Warner customer, you would have access to certain sites. If you're a Verizon customer, you would have access to other sites, all based on their whims.
That's exactly right. Just think cable system. Anytime this issue seems a little complicated, that's exactly what Verizon and the other actors want to be able to operate when it comes to internet access as well.
Wow. So, if you're a Netflix customer, you have to go with whatever internet provider has cut the appropriate deal with that service that you'd be able to access it.
Right. And Netflix, really gave up before a shot was fired. It's really a complementary service. They're not trying to compete directly head-to-head with cable. And in fact, right now, Netflix appears to be making some deals with the cable operators and others so that it will get good treatment. So you can anticipate you'd have an internet with some very famous sites that were able to pay for good treatment by Verizon and others, and everything else left to its own devices.
So the First Amendment argument sounds scary and interesting. It'll certainly be very enlightening to read the D.C. Circuit's treatment of that, how they decide to come down on it. What do you think the D.C. Circuit will do with the authority piece?
Well, again, they've got this tricky statutory thing. The FCC is claiming something called ancillary authority to issue the open internet rules. That authority has to be ancillary to something. They have to be able to point to some part of the statute that would support the non-discrimination obligation for wired connection and the no blocking obligation for Verizon's wireless connections. If Verizon wins, that means the FCC has no authority to impose any of those rules.
And you mentioned that, okay, so if we take that to the next step, say if Verizon wins, that there could be some relabeling of high-speed internet services. Don't you think that kind of sounds too cute by half, that some court or some oversight body would definitely look at that move by the FCC and say, okay, well, that's just a responsive step and it's not going to get you where you need to go?
No, really not at all. In fact, Justice Scalia might be our proudest supporter at that moment, because administrative agencies get to change their minds. 10 years ago, the FCC labeled high-speed internet access as what they call an information service, an unregulated service. That was a mistake, I believe, at that time, and it's certainly proven out to be a mistake now, because these are basic utility services that all Americans need in order to participate in the 21st century. All the FCC has to do is have a good reason to change its mind. It can build its record, it can hold a few hearings, it can gather information about how Americans perceive internet access, and just present that to the court the next time they're challenged. And Scalia has said several times that as long as we can discern a good reason for what an administrative agency has done, then the court should defer. The court should be very polite to the FCC and let it do its administrative expert work.
That's good to know. I'm glad to hear that Justice Scalia has considered this and given some insight. Art, do you have any thoughts on this case and on net neutrality in general?
Sure, absolutely. And we participated a couple years back in the various proceedings regarding net neutrality and the broadband legal framework. And if I also should mention that I'm on the FCC Consumer Advisory Committee, and I'm chairing the broadband working group this year as well. And I really appreciate Susan's perspective, and seeing firsthand up close some of the things the FCC. I'm excited for a leadership change, excited to see what could happen, but sometimes it can be a little bit disheartening to see the capture that happens at our federal agencies. And I appreciate the kind of independent perspective that Susan brings to this, and I've always respected that. This case is absolutely critical. I mean, it affects all the folks that we work with on a day-to-day basis. When you change the internet, as Susan alluded to, you change the way that folks are who are creating and trying to start innovative kinds of services and mobile apps, you change their ability to share their creativity and to do business. And, I avoid sounding the alarm unless it's absolutely necessary. In this case, it really is an instance where we have to sound the alarm that this affects the future of the internet. This affects our ability to have an open internet that sort of puts content providers on equal footing. And the outcome is critical. So the FCC has to be able to stop internet access providers from interfering with your right to access lawful content. They have to have that right. And they have kind of given that away to some extent over the last 10 years, as Susan mentioned. It really needs to, I think under, the new commissioner and everything, the FCC needs to show that they have the right to regulate internet access providers, partially also because we're going through an IP transition now. We're moving to heavily IP communications and moving away from copper. And so it becomes even more important to say that the FCC does have a role in, regulating the internet and internet access providers. I like Susan's sidewalk analogy that she used in her blog as well as in other places. And I think the sidewalk just frankly needs to be a sidewalk, right? It shouldn't be deciding who can walk on it. And I know analogies break down quickly, but I think that's a fair one. The most interesting thing I saw in this case, and it was particularly in the amicus brief that Susan, you had linked to, where Michael Copps and you and some other telecommunications heads of various organizations had submitted an amicus. And I think that's the best piece I've read debunking the First Amendment arguments from Verizon. And Verizon's, the idea that Verizon is even speaking in the first place is ridiculous. And then the idea that they're somehow, impinged from speaking is also ridiculous. So that First Amendment argument is really critical to strike down. This also dovetails. I mean, I was just talking to a telecommunications attorney in Massachusetts who, I think Massachusetts would be unlikely to pass this kind of bill, but there are bills floating around state legislatures. And we had a bit of a deregulation here in California last year, trying to deregulate at the state level as well. And this is all just a sort of all hands on deck effort by telecoms to sort of deregulate themselves at both the federal and the state level.
Susan, as we're talking through this, the whole notion of whether an ISP can be a speaker for First Amendment purposes, it seems to me that you could envision a scenario, maybe, a law school final exam kind of question, what would it look like if an ISP were actually going to be a speaker? If we think about how much attention has been paid to filtering the internet and various laws and steps that have gone in place in the UK in recent months, you could see an ISP maybe coming out and trying to compete, saying, we're going to give you, for example, a safe internet. Yeah. We're going to shepherd and aggregate sites that we think are going to be good for you, good for your family, et cetera. And we're going to do that curation for you so that you don't have to think about it. Could you see someone that was trying to compete in the marketplace on that ground being a speaker?
Well, this is the fascinating thing about this argument, that Verizon has to be beat back now, because if we don't say the First Amendment argument is ridiculous, which it is, then just in the passage of time, ISP's ability to edit, filter, decide, market themselves based on their policies will make them into speakers. And the argument gets strengthened as we do nothing about it. And it's just, this is a technology of freedom. This is a technology that allows anybody to speak without permission. And so far, ISPs are not competing on the basis of their editing capability. But as they gain bravado and strength, they may start doing so. And then the legal argument against their First Amendment claim gets weaker. So the timing here is absolutely critical.
Right. So do you think that that's something that the DC Circuit's going to take into account?
It looks unlikely because Verizon's going to keep making this argument in every form it can. They're just unleashing it now in this particular case. The DC Circuit can decide the case before it on pure administrative law grounds. That is, whether the FCC actually had authority while deregulating to pretending to regulate. They don't have to reach the constitutional question. But I promise you that in every think piece and every set of bullet points, both the cable industry and the telcos will be reminding everybody that they're speakers, they're speakers, they're speakers. And this happened in the healthcare debate, too. The entire Commerce Clause claim made against President Obama's health initiative was ridiculous on the face of it, but it was repeated and repeated and repeated until it was taken seriously by one court. And so my effort with the brief that I filed before the DC Circuit and in articles that I'm writing now is to make sure that nobody takes this First Amendment argument seriously.
All right. Well, we will look forward to keeping up with your writings and advocacy on that front. Is the authority question becoming a partisan one? It seems like the Republican side of the fence might view this as government overreaching.
Yeah, it shouldn't be partisan because Republican businesses and Republican speakers do just as well as Democratic ones with a free and open internet. The problem is that because of campaign contributions and, there's really no upside to taking on the telcos. They're some of the greatest contributors to campaigns in the country, greater than Goldman Sachs. They give lots more money. So no upside to going against them and a lot of upside for weighing in on their side. And here, something we have to be really careful about is never to say the FCC seeks to regulate the internet. That's not what's going on. That's a talking point from the Republican side of this stuff. The FCC wants to have authority over internet access, just as it has authority over phone lines and basic general purpose communications networks.
Art, thoughts on this?
Right. Yes. So one of the things that was interesting to me, and maybe Susan could speak a little bit more to this, but as somebody who deals every day with Communications Decency Act Section 230 and also with the DMCA Section 512, I thought that was interesting how that played into this case. And I haven't seen every brief in this case, but I've seen it pop up periodically, where it's mentioned that there's, in addition to all this case law that says, okay, Verizon's not really speaking and they're not really being impinged by speaking, there's also this duality of the argument where CDA 230, actually guards against intermediaries from being liable for illegal things that third parties do using their services. And so Verizon is really not treated as a speaker under CDA 230. And in some respects, you could argue it's similar. They're not going to be treated as speaking or actually making a copy under Section 512, the DMCA. And it was interesting to see those provisions as an internet lawyer, to see those provisions invoked in this case, which has to do with so many basic kind of communications law and First Amendment issues. And I don't know if Susan, kind of some of the more detail in terms of how those provisions have come up in this case and how they might play into the court's decision.
Look, it's so important in the long run for Verizon and Comcast and the others to get constitutional scrutiny of any attempt to regulate them. That's their top goal, to make sure that any attempt to even have competition policy would be viewed as presumptively unconstitutional because it would be stepping on their speech rights. That's their goal. They want to get there, and they're happy to give up on the shield to liability given to them by other sections of law. So you've mentioned Section 230. We've also got the notice and takedown provisions of the copyright law. From Verizon's perspective, forget that. They'll deal with the liability when and if it shows up for user-generated content. They want freedom to charge, and they want to charge at both ends of the network, both connecting networks and users, whatever they want. And that allows them to make more profit. It's totally rational, and they'll do well on Wall Street with that.
Well, I'm going to sound the alarm again then, because this is a double. I mean, this is not only, does it have this First Amendment argument that really needs to be struck down. But if the First Amendment argument wins, and if Verizon were to actually win some kind of argument that, hey, we're going to give up our immunities under CDA 230 or even 512 to some extent, that's a real concern. That's a real concern because we work with people every day who rely on those immunities and safe harbors. And to think that in addition to the inability, taking away the FCC's ability to regulate internet access and people's ability to access information online, in addition to that, thinking that this important protection for websites and independent creators that exists, both CDA 230 and DMCA Section 512, could also go down in this case as well is a bit disturbing.
All right. Well, we're already getting into policy issues, talking about net neutrality here in the context of this specific case that's pending in the D.C. Circuit. So why don't we keep on the policy front and look at a few more things in that area? So we've been discussing the FCC. The FCC is on the brink of having a new head now that Julius Genachowski is no longer helming the organization. We have Tom Wheeler teed up and ready to go, but his nomination is currently being blocked by Ted Cruz, who has some questions about his stance on the FCC's authority to require disclosures of funders of political ads. So he has not been confirmed yet. And the folks in Washington seem to be bickering over whether this is just more sort of blocking of keeping the government operational here. But assuming he gets confirmed, it looks like that is going to be the case. What sort of head of the FCC do you think he will be, Professor Crawford?
Well, Tom Wheeler, I know Tom because we worked together on the transition between the Bush and Obama White Houses. And I think very highly of him. He's a very good manager and has absolute iron decisiveness. I think we'll see that morale in a Wheeler FCC will be pretty high. I think he'll be very data-driven. What we'll see is, I'm hopeful anyway, we'll see him asking for much more information about what's actually going on these networks and how discrimination is happening or not happening at interconnection points and in the last mile. I think he'll be very interested in the FCC's retaining its authority over high-speed internet access. I'm really sad about his being held up over campaign finance disclosure, which is in essence what's going on. And this shows the great link between giving to campaigns and power over communications policy, that Wheeler could be held up over whether or not he's going to promise that the FCC will never oblige broadcasters to actually force sponsors of ads to give details as to the entities and people behind political advertising. That's just shameful. And it also puts Wheeler in a very difficult position because he can't promise in advance what the FCC will or won't do. It's a tragic turn of events. And this is why it would be good if the Democrats controlled the House. And I wish we could take it back in the next election.
Well, we will see what happens there. Any thoughts about the new FCC head, assuming that he does become the FCC head, Art?
Sure, absolutely. And as I said, I'm on the Consumer Advisory Committee at the FCC, and I think there's been interest in, there's been a lot of recommendations that have come through that committee, and I think we have some ideas about doing I'd like to do some real tangible things on that committee, but I think it's going to take an active commissioner, and I'm really heartened to hear Professor Crawford say the things that she said about Tom Wheeler, and I know that she also backed his appointment, so that's great. I mean, we're also aware of his past as well, but I think I'm really excited at the opportunity. I'm just hopeful that Mr. Wheeler will see a constructive role for the FCC in prohibiting discrimination amongst IAPs and internet access providers, including the wired and the wireless. And also, though, in making sure that just some basic consumer protections continue to exist. I have a lot of communications background, suing telecommunications companies for mischarging people at the state level. And there's a lot of things that need to be improved at the FCC. One thing is just simple, outside of the basic net neutrality piece, there's also other issues at the FCC in terms of the way that they report complaints, for instance. If you've seen Elizabeth Warren's Consumer Financial Protection Bureau, the way that they're doing complaint reporting and how useful what they're doing is, the FCC is way behind in that department. And, there's also a lot of reforms that need to take place on E-rate and ConnectEd. And E-rate and ConnectEd are what fund our internet connection, high-speed internet for schools and libraries, and subsidize that to make sure we have world-class internet to our schools, to our young people who are the next generation of folks that are going to help this country stay competitive in the future. And that is also really important. So I'm hopeful. Those are the things I'm worried about. I know that Senator Cruz is worried about, whether or not, there are certain campaign ad disclosures that have to be followed by the FCC, and whether Mr. Wheeler agrees with that. But I'm more interested in Mr. Wheeler's approach to ensuring that there are basic consumer protections that continue to exist at the federal level.
And another question that is always near and dear to your heart, Professor Crawford, is access to the internet and having the United States be competitive in that regard, as far as having everybody connected and having the speeds and reliability that we see in other countries. Certainly, do you feel like Tom Wheeler will have that on his high on his list of things to look out for as well?
I feel that he certainly cares about high-speed internet access. No question about that. And he understands what's going on in other countries, and particularly in Asia, where the commitment to fiber to everyone is very strong and services are very inexpensive. In my great city of New York, we have pretty lousy access, very expensive, and in the outer boroughs, often non-existent. More than 2 million people in New York don't have a wire to their home. So we've got a big problem as a nation, and Mr. Wheeler is vitally aware of that.
Can you tell us a bit about progress that might be being made in that regard? I know that you work closely with the city of New York on those kinds of issues, and across the country. How do you feel like we're doing on things like municipal Wi-Fi?
Well, I'm not too focused on municipal Wi-Fi. Wi-Fi is just sharing a wire. I'm really focused on municipal fiber, because that's going to make possible very high capacity, low latency applications for things like healthcare, education, new ways of making a living, actually being present to other human beings using a communications network, something we haven't yet seen. So mayors are real sovereigns in their areas and are able to take action on fiber networks. I've been meeting with a bunch of mayors who have made progress and say that it's the thing they care about the most. The city of Santa Monica has a terrific fiber network to every business and is intending to extend it to every home there. I grew up in Santa Monica, so I'm really proud of that. At Chattanooga, Tennessee, a lot of you guys know all the familiar players here, Lafayette, Louisiana. I think we're going to see a dozen or more such mayoral success stories in the next year or so. And that's when policy at the federal level may really start to tip, when mayors get jealous of mayors in other states that are able to take care of their citizens, and when the whole country says, well, why can't everyone have reasonably priced fiber access to the home? We went through exactly the same set of steps when it comes to electrification of America. There was a time when 90% of farmers didn't have it. It was viewed as a luxury. There was a time when private trusts controlled all of electricity distribution in America. And it took very strong leadership to change the picture for coming from FDR. We now need leadership like that to change the fiber connectivity story for the country. Because right now we're stuck with a series of private monopolies that have no particular incentive to upgrade. So the bright light for me is the mayors. And it's a difficult issue, but many of them are making a lot of progress. And so if you want to know how to be active in this issue, the thing to do is to give your mayor air cover, to get involved, to say this makes sense for us as a community on every level, to ensure that everybody has affordable, very high capacity, low latency access.
It's just incredibly appropriate that in the middle of your comments on this, my Skype video has actually frozen on my end, even though I'm on a wired connection at home. So you guys can see me, but I can't see you until the studio calls me back. And this is the kind of thing that we deal with all the time, because even though I have, as a very nice internet connection through Time Warner Cable, 15 down and 2 up is pretty good for high speed in the U.S. It's certainly not a fiber connection, and it doesn't have the reliability that can handle things like what we're doing right now. It's a little bit frightening. Let's shift real quick and talk about something on the copyright front.
Oh, could I? Oh.
Yes, you can in a minute. I'll let you jump in a second, Art, but this
Sure.
actually tied into our discussion of participation via internet access, being present in places where formerly you had to show up in person, ties into this report from the Copyright Office that just came out, recommending the establishment of a small claims copyright court that would be administered out of the United States Copyright Office in D.C. And a piece of making that work is the Copyright Office envisions people to be able to be present in these proceedings remotely via Skype or something else. And that's how it would work. And it was really fascinating to me. There's so much that's fascinating about this small claims copyright court proposal. But just the administrative nuts and bolts of it, having people appear remotely like this in a sort of more abbreviated kind of proceeding than a traditional court proceeding. And also, it sort of takes the jurisdiction question out of play. Can you sue someone in this state and force them to come across state lines to have to litigate a small claims copyright case? Well, that's really not a big deal if everyone is going to appear in these proceedings remotely. So I can definitely see, Professor Crawford, where courts and things like the Copyright Office are looking ahead to a future where we need to have reliable internet connections for people to be able to participate at a very fundamental level in the justice system.
Yeah, this is, it's almost too obvious to say, but everything we do is going to depend on a very reliable internet connection, just as everything we do depends on a very reliable utility electrical connection. There's really no distinction. One's for speech and the one's for power, and we need to make sure that everybody has access at a reasonable price.
All right, Art, go for it.
Well, I was going to say, along the lines of what Professor Crawford was saying, is not just everything we do relies on a fiber and high quality, fast internet, reasonably priced internet provided to folks, but things that we can't even imagine, right, rely on that. And when I was preparing a little bit for the show, I noticed that Samuel Morse, back in 1844, demonstrated the telegraph over a federally funded line that was run from Baltimore to Washington. And so I think that, it's a chicken and egg thing. When you provide gigabit service to folks, right? Like, let's say the Netherlands has done that to a lot of homes. What that enables in terms of innovation, we can't even predict. So it is really, really important. And then you're right, in this case, with the small claims copyright court, it can also encourage innovation in terms of not having to have people fly all over the country, and maybe perhaps making our court systems a little bit more efficient. And so, this small claims proceeding is a really, really big deal, because not only does it lower the bar for folks in a variety of ways to bring copyright claims, But when you do that, I think it's really important to keep some of the basic safety valves involved in the process so that folks can adequately defend themselves against really kind of abusive copyright claims.
All right. Well, in a moment here, I'm going to want to get into more detail on the small claims copyright proposal, which is pretty interesting. And I think, Art, you'll be able to tell us quite a lot about that. But we know that Professor Crawford needs to scoot on her way and take care of all of the wonderfully important and vital things that she's doing to make sure that we can continue to enjoy the internet in a way that we have all become accustomed to, and maybe even in a better way than we've become accustomed to. So I'm going to let you scoot out in just a moment, Professor Crawford. I did want to go ahead. We usually reserve our resources and tips of the week for the end of the show, but one of our resources this week is your book, Captive Audience. So I wanted to have you tell folks a bit about that. I will tell you that you have 2 sales coming your way. I have 2 family birthdays coming up in the next couple of weeks, and your book is going to be great for both the recipients who are going to find it fascinating. So please tell us a bit. It came out in January of this year, why you wrote it, and what people can hope to discover when they read it.
Well, I had a short stint in the White House at the beginning of the Obama administration, and I was changed by that experience, I think it's fair to say. And I decided it was going to be very important to explain to people what had happened in telecommunications over the last 10 years and how concentrated and powerful the market actors had gotten, and how unlikely it seemed that the U.S. would have the bravery or the leadership to make an upgrade to fiber as a nation and to treat high-speed internet access as the utility it was. So I decided to write a book, and I focused the book on the Comcast-NBCU merger, a titanic merger that was hardly covered by the press at the time. And I try to make it as entertaining as possible, tell the stories of how important sports is, for example, all the characters in the cable world. And it's gotten a lot of attention, and I've been delighted by that. My next book will be less wonky and even more human, because this is all about imagination and shared understanding of what it means to be a nation and how we help people flourish and when we act collectively.
That's wonderful. Thank you so much for joining us today, Professor Crawford. We look forward to following along with all of your writing and testimony and the great, wonderful works that you do out there in the world. Thanks so much.
Thank you, Denise. It's been a real pleasure. I really appreciate it. Take care.
Take care. All right. Well, that is just a rush getting the chance to speak with Professor Susan Crawford. Let's get back into, and let's drop as well as long as we're sort of taking a quick breather from our dialogue, we need to insert a passphrase so that people listening to the show for continuing legal or other professional credit can go ahead and demonstrate that they've listened to the show. So we may as well just make net neutrality the first one, since we had a long discussion about that. And it's even bleeding over into our discussion about the copyright small claims recommendations put out by the Copyright Office. Now, it just seems to me, and I think we've discussed it before on the show, to make perfect sense that there be a forum for resolving copyright claims that does not subject the litigants to all of the arduous things that are involved in a federal court case, which, the hefty filing fees being just one, the having to cross various state lines to litigate in different locations is another. Any kind of litigation is going to be a pretty onerous burden on your average citizen and your average creator too, right, Art?
Absolutely. And I just want to say also that it was a huge thrill for me to be on with Susan Crawford as well. So I appreciate you having me on with her as well. And that was a very, very smooth transition, I do think, from the previous topic to our small claims topic. I thought that worked out really well.
It did.
There's really 2 paths here. I think that's right. I think that definitely the small claims court does present an option for making things more efficient. I mean, in the record in this proceeding, they broke down by region the cost of copyright cases. And even before trial, we were talking about hundreds of thousands of dollars, even in the less expensive jurisdictions. So it gets very expensive very quickly. And it is fair to say that there are some folks who have maybe one-off cases with one work that really don't necessarily have an outlet, don't have a way to kind of pursue infringement. But I think there are two paths that this court could take. This could simply be a new place for not just enforcement, but over-enforcement of claims. I know you had Lee Chang on here a couple weeks ago, and I felt like I was a bit of a soul brother with him in terms of on the copyright side, because that's what we deal with, right? A lot of copyright trolling. In fact, behind me is a picture of a Street Fighter II style picture of us punching out a copyright troll on the on the title page of the local magazine. So there are really two paths here. One path is that you lower the bar so low that plaintiffs can simply utilize this as a new forum to bring really specious claims against folks and extract settlements out of people, extract a couple $1,000 here or there out of people. The people I'm thinking about and the plaintiffs I'm thinking about here are the folks who have brought these mass file sharing lawsuits right over the last couple of years. Folks even like, I'm even thinking of bigger folks like Getty, who send letters all the time to websites. And we see that all the time. We pay us $600 and it's a letter, but it also happens to look like an invoice. And so I think avoiding shakedowns in the system is really important. So you've got to make sure that you provide, the other path is to provide a more balanced system where you allow people to access the defense of fair use, that you allow them access to counsel, that you allow folks who get nasty cease and desist letters or abusive takedowns to actually bring declaratory judgments, right? And to get the small claims court to say, look, what you're doing, this innovation that you're doing is fine, go ahead, and they can actually get a declaratory judgment. Because right now, for every couple of folks that we help with some kind of a takedown of an app, right, or with some kind of a takedown of a YouTube video, there are many other folks who come to us with gray area issues, and frankly, they're making oftentimes a business choice, especially if it's some kind of small business, and they're having to decide, do I move forward with this, or do I just kind of decide not to move forward? And so this proceeding is really important in terms of providing, really guarding against over enforcement of copyright law. So we made a number of suggestions. We thought that defendants should have access to all the defenses that are normally available to them, DMCA and fair use. We wanted to definitely keep this out of the state courts. And it appears, with the report that's come out, I was excited to see that the report that came out did include a number of our suggestions and other folks' suggestions. I think from a larger perspective, though, this is a really good lesson in why it's important for folks to get involved in regulatory proceedings early and often, because this was really just a study that was asked for. So if you go back and you look at what Lamar Smith, the congressman who requested this from Maria Pallante, who's the head of the Copyright Office, back in October 2011, he basically said, look, I had a hearing back in 2006, and I think it would be great for us to look into whether or not we need a small claims copyright court and what that would look like. And not only did she come back with a study of, well, here's what we could do, but they actually came back, the Copyright Office, with a specific piece of draft legislation, which I don't think everybody necessarily expected. And when I spoke to a lot of people early last year, when the whole, we were involved in doing comments to this proceeding and testimony, and, there really could have been a lot more groups commenting on this proceeding. And there also was just not that many folks, even at the testimony in LA. It really wasn't that many people, maybe 15, 20 people. And George Clinton showed up one of the days even. But that was about it, So it's important to get involved early, because now, procedurally, what we may see is, this legislation will go to Congress, and perhaps, if Congress is already proposing this version of a copyright court, there may not be another opportunity, or there may not be an opportunity to get into really the nitty gritty details. And this might have been the only opportunity to do that, or the key opportunity to do that. So it's really important early on, because a small claims court like this really does affect the average internet user who's getting told that they're, grandma and grandpa who are getting told that they're downloading some kind of movie, or somebody who has a claim against them in terms of copyright infringement for their mobile app or for a video on YouTube. And there were a lot of sort of bizarre suggestions made in this proceeding that really had to be called out. I mean, there were groups calling for dropping the DMCA safe harbor defense and raising statutory damages to $650,000. And so it's really important to realize that there are going to be people at the table suggesting things sometimes that seem outlandish, but that we really have to be there to make sure that these systems end up being balanced. But I think in the end, it's looking all right in terms of, they make sure that folks are going to be able to have access to legal representation. They don't have to sit there and come up with the fair use arguments themselves, right, in front of a court, which would just be silly.
How's that going to work, Art? Is it going to be sort of a public defender kind of system?
Okay, so they have appointed, if anybody's looking for a job, they look like they're going to create 2 positions, expert copyright attorneys. I think they have to have 7 years of experience. And right now, it looks like there are 2 for the entire country, which looks a bit inadequate for what I imagine would be needed in the system. So right now, there's 2 attorneys. And I think you can also, of course, bring your own attorney. What I'd like to see, I haven't seen it yet, we actually worked with Federal Legal Assistance Self-Help Project in Northern California. And, we support, and I would really encourage the Copyright Office to work with projects like New Media Rights, like Flash up in Northern California, and other legal clinics to try to create a network. I think this is what's really going to be necessary, is to really try to create a network of folks who can step up and help with the basic kind of legal assistance that's necessary in these cases. And there's precedent for that, right? Because the USPTO right now has rolled out a number of programs, and a bunch of clinics around the country are rolling out trademark clinics and patent clinics to help get law students and law clinics involved in providing services to really underserved folks. And so I'm not sure exactly how it'll play out. Right now, though, they want to appoint a couple of attorneys to handle the cases.
Right. 2 seems woefully small, especially given the concern that you voiced at the beginning of the discussion that what we may be setting up here is just a more streamlined way, a more cost-effective way for people like the MPAA or other large copyright holders to shake people down in a more efficient, less expensive way, where their upper end damages aren't going to be as high. It looked as though the recommendation was to cap statutory damages in the small claims court at $15,000. So that's significantly less than the $150,000 per occurrence statutory damages that would be available in a regular federal court under certain circumstances. But still, $15,000 is a lot of money to anyone. And the upper end for non-statutory damages, it looked like was going to be $30,000. So still, that gives plenty of wiggle room to troll, I would think.
Absolutely. I mean, that's definitely well within the amount that folks try to troll for in the copyright world. I know with a lot of startups, in terms of the patent world, they're looking a lot of times at 20, 30, 40, 50,000. When you're talking about individual internet users, they're usually approached, or small-time forum owners on the internet, they're usually approached for 500,000, 2,000, and certainly that would fit within the amounts here. So, and I guess there's just a concern, once again, that exactly, they'll be able to use this and send out a bunch of letters that look really formal and, hey, you're in a formal proceeding. And really, it's not intended to take it all the way through. It's really just intended to get people to settle and to shake people down for settlements. And as we know, if you're putting together a copyright case, right, an offensive copyright case, you've got maybe a 3-year statute of limitations. You can take your time. You can put it all together, get all your ducks in a row, get your attorney. But once that case gets rolling, the defendant has to be ready to answer and move. And especially in a really kind of more efficient, quicker proceeding like a small claims court. And so it's really, really important that the defendants get adequate representation.
Right. Yeah, that seems to be the key piece. And 2 lawyers, as you say, aren't going to cut it for that. So where do you think things are going to go from here, Art?
Well, like I was saying earlier, I was a bit surprised to see such a not just detailed report, but specific legislation. So, I mean, the government's back up and running now. So maybe, I don't know, this probably, Congress could take this up. I don't know that they take it up anytime soon, but perhaps next year, they could consider this. I imagine there'll be other rounds of testimony, and there may be some more rounds and possibilities for input from the public. And I strongly encourage folks to take those opportunities and be involved, because as far as I can see, looking back on changes in copyright law in terms of the DMCA being passed in the 90s, or some of the reforms that took place in the 70s, this is a pretty massive, and copyright extension in the 90s. This could be a very, very massive change to copyright law, not to mention the other, which we may talk about later, the larger study that's being done and work that's being done to actually overhaul copyright law in its entirety. The small claims sum by itself could really change the balance between plaintiffs and defendants quite significantly. And so I think folks should keep a close eye on this. Oh, go ahead.
Can you kind of expand on that for us? In what way do you see it most likely changing the balance? I would say right now that defendants are kind of running scared. Do you think that this could ameliorate that?
Right. Like I said, I think there's the 2 paths. There's a path where defendants could really have a chance. We could start to really reduce a lot of the specious DMCA claims and other kinds of cease and desist that go out from folks by really having a forum for defendants or declaratory judgments, right, to be brought and to actually penalize folks for bringing ridiculous copyright claims, which are just not going to be brought in the federal court system right now. On the other hand, if you do not create a system where if defendants win these cases, under the Fogarty decision in the Supreme Court, that they get their damages, if you do not create a system that gives folks a chance to get a declaratory judgment against a troll, then you are just creating a new place for trolls to keep defendants on the run. And then it just sort of extends that bullying, I think, even further. So I'm saying it could go either way, and it really depends the shape that the court takes and the shape that Congress gives it when they consider legislation.
Right. And now the report was well over 100 pages long, so I skimmed it at best, but found the whole thing fascinating and do want to go back and read it in more detail. But one of the things that could tip the balance more toward making it more advantageous if you're someone that is on the receiving end of the lawsuit, the defendant, is it seems as though the Copyright Office wants to include the DMCA safe harbors as a defense, and that it would enable the defendant to make arguments and pursue the argument that the takedown notice was in bad faith and go forward under 512F and pursue the remedies that are available for that if you have not adequately done your research and have sent a takedown notice nonetheless. Am I right about that?
Right. I mean, so they do appear to allow people to access defenses like the DMCA and fair use. And it does appear that folks can access 512F. As we may get to in our reform discussion, I am concerned about the viability of 512F. I just don't think in its current version that 512F does enough for the defendants in these cases.
Let's get into that because New Media Rights has joined 17 or more than 17 other groups in the debate about reforming copyright law and is definitely lobbying Congress to take a close look at the laws the way they are and how they should be adjusted to better serve the needs of the public and better reflect what people are actually able to do with technology. So you think 512F is one of the things that we need to expand, it sounds like.
Right. Well, 512F is one of those things that we need to address, that we need to figure out how to provide. There is a lot of abuse in terms of takedowns, and the practical situation is that the standard in 512F is that the sender of the takedown notice, or counter notice for that matter, has to knowingly, materially misrepresent something in the notice. That is a very high standard. And also, it's very unclear what damages can be recovered. I understand that I'm not sure. I don't think we've gotten any final word on the Lentz case, but there continue to be decisions that come out. And in January, I believe there was a decision that awarded, based on the 512F damages, the EFF was awarded something like $1,275 for Marsha Hoffman's work on that case. And, it'll be interesting to see if damages can actually be given to folks who bring these 512F claims. And right now, it's such a high standard for these senders of these takedown notices. They have to knowingly, materially misrepresent something that these cases rarely get brought. There's really not more than, I don't think there's many more than 15 of these cases, and it's been in existence for 15 years, but there's not very many of these cases at all. And we see pretty textbook examples of fair use where we have to really think twice. And we're one of the groups, we're the type of group that's going to be able to bring these cases. I just don't think private attorneys can, business-wise, it's very difficult for them to make a decision business-wise to bring these cases. It's more of a pro bono, public interest purpose bringing these cases. And I think that we need to make it a little bit stronger right in terms of going back after the content bully. But that whole proceeding that you're talking about is very interesting. It was, I don't know if folks are familiar with the green paper that came out.
No, tell us about it.
Okay. So, and I don't know how, I know that the NTIA has come up on, I listen to This Week in Law, and I know that the NTIA has come up in a couple recent discussions. And here's another place where the NTIA pops up, and they, along with the USPTO and Department of Commerce, in collaboration with the Copyright Office, are really holding a task force and a series of proceedings, and where the idea, as you said, Denise, is really to revisit the balance of that copyright creates between giving a monopoly over creativity and allowing the free flow of information and the right to innovate as well. And there's a green paper out there which is totally worth reading, and it gives you a sense of where we stand with the current copyright system. And there was a lot of folks who gave input on that. I thought if you read that report, there were some really interesting stats, which I do think contradict a lot of what we hear from some of the Hollywood folks and other folks that are concerned about file sharing and infringement. One of the key stats that I read in there was that copyright-related industries have grown 46% in the last 20 years. And that was faster than other IP industries and faster than other non-IP industries. So what I think is really interesting about that is it does show on a base level that the creative sector is sort of alive and well and growing, and that we should be careful to parse out what we're doing that is simply propagating an antiquated business model versus actually just creating a forum for people to create. And so it seems like generally the report from the federal government, the Department of Commerce, which is one of the groups that follows these things.
The National Telecommunications and Information Administration is part of the Department of Commerce. That's what the NTIA is.
Exactly. And it is one of those interesting situations where it's the USPTO and the NTIA that are sort of leading the way on this. So the Copyright Office is kind of involved, but they're sort of leading the way because I guess USPTO is technically the main advisor to the president on intellectual property issues. But it's a huge amount of areas that this call for comments covers. And what happened with what you were talking about, these 17 groups getting together and asking for the deadlines to be extended. Well, originally at the end of September, right before the government shut down, the NTIA and the Department of Commerce said, hey, we're going to have these comments, and they're going to be due November 15th, but actually we're going to have a meeting October 30th. And if you have comments in by October 15th, that is 2 weeks from the day they put out the notice, basically, you can be considered at that first public meeting. And a lot of groups said, hey, you're asking for an entire analysis of copyright law, and maybe you could give us 45 days instead of 15.
Would be nice
to rewrite copyright law. So they did. They said, we're going to have a meeting in early December, and the first set of comments is due November 13th, though. So I would just say to everybody, look closely at those, the call for comments on the FCC's website. I'm sure it's in the show notes. And look through those questions. And if there's a question, particularly if you're a filmmaker or a creator or somebody who is creating and sharing new kinds of services, both web services, mobile apps, make sure that you have your voice heard and answer those questions that are relevant to you. If you're a remix creator, get your voice heard in that proceeding, because what comes out of that may be a comprehensive look at copyright law and revisiting of copyright law. So, in that proceeding, they say we're going to look at the legal framework for remixes. They say they're going to revisit the first sale doctrine in the digital context. That's a big deal. They're going to look at statutory damages. They're interested in the government's role in improving online licensing environments. And they're also interested in the operation of the DMCA notice and takedown system, amongst other things. So there's 20 some questions in total, and it's very comprehensive. So it's an important proceeding. And as far as the things that we're most interested in, I think we've already mentioned we're interested in abusive DMCA takedowns. How do we curtail those? How do we provide a real response mechanism for folks, not the current 512F, which is just too high of a standard for people to really bring cases and to really get any damages out of it. Because what happens is it's just chilling a lot of speech. I mean, we fight for folks like Jonathan McIntosh, who was taken on by Lionsgate earlier this year. His Buffy versus Edward video, people may be familiar with. We fight for things in the library. They're taken down by Sony. But there's a lot of folks who abandon projects to synthesis, and they just decide, I just can't. I can't decide to go forward from here.
Right.
I think that abusive DMCA takedowns, I think, is something we're going to be writing a lot about. There's also some low-hanging fruit that I think the Copyright Office could really address. One that we see every day is a lot of folks who want to reuse content. That could be a remix creator, or that could be somebody restoring and improving. They ask us questions like, hey, is this in the public domain, right? And it's much harder than people might think, once you get after 1923 and you're in that sort of box of 1923 to 1978, it's very difficult to actually identify for folks whether something is in the public. And a lot of the relevant information, like what's ever renewed, that all exists in paper form at the Copyright Office, but nothing before 1978 is digitized. And so what happens is it's very difficult for folks to really guarantee and understand that something actually is in, excuse me, the public domain. And so, and if they want to find out, they don't just call the Library of Congress. They actually have to pay $165 an hour to access that content, or they have to fly to DC, or maybe they're already there, so they're lucky enough to be able to walk down the street. But the public domain in accessing information about what is already in the public domain is difficult as well. The other two things that I'm sort of most interested in here are turning to another topic, which is the anti-circumvention provisions, which we all, the public interest groups, the entertainment lobby, the information technology sector, we all battle about these exemptions every 3 years, right? When can we circumvent technological protection measures, right? I just think there's room here, instead of battling over, well, this time we can open up phones and we can install the apps of our choosing, which is something we fought for last time and provided direct evidence and support to the EFF's exemptions that they had proposed, or the right of remix creators to access DVD content or online video content for purposes of fair use. Let's just say, one of the travesties of copyright law that currently exists in the code is you technically can be guilty of circumvention even if you've made a fair use of something. And that should never be the case. And so I think there's a chance to revisit that code, not just to empower users, but also to empower some business models, and to just say, look, if it's circumvention for the purposes of fair use, it's not breaking federal law. And that seems like an obvious one to me, but it's one that's been lingering out there for many years. And I think it's a chance to address it. And, there's other things that I'm concerned about that I think affect everyday folks who are trying to build upon existing content. And some of those may seem a little outlandish to folks, but I think that one of the things that we seriously have to sit down and think about at some point is, why are patents, 20 years, protected for 20 years, and why are copyrights protected for life plus 70? And it's just, I know there are folks that, I think it's something that we need to really consider carefully, because the economics of it are such that people who are creating copyrighted works, particularly, I'm talking about industry folks that are creating copyrighted works, even like movie studios, and don't think of more than a decade, out. Why? Because a dollar made 10, 15, 20 years from now is pennies for what is made in the next 5 or 10 years. So in terms of our copyright law, we're interested in the United States, we're interested in getting new works created, right? That's the basic balance that we usually see from our Supreme Court. It's this utilitarian view that, we're it's almost a necessary evil. We have intellectual property protection, which I think is fine to have intellectual property protection, but the length of time creates a ridiculous tax on downstream users, and there's no economic reason. I mean, forget all the other. All the other reasons are very important as well. The moral reasons and the creative reasons why that makes sense. But if you want to get even into the economics, studios aren't thinking, well, I don't know if I'm going to create the 18th version of CSI because I don't know if I can license it 20 years from now. They're not. Is
there a way we can create that incentive? I'd like to, if we could. Let them have that thought.
Let them have what? I'm sorry.
Let them have that thought. Second thoughts about creating the 18th version of CSI. That would be good.
Exactly.
Yeah.
So I think there's some low-hanging fruit that could be addressed in the proceeding, but I also think folks should be thinking broadly and saying, hey, look, this is perhaps a once-in-a-generation opportunity to fix up copyright law a little bit, to revisit some of those things that we think are just ingrained and perhaps, just seems to be ever expanding in terms of the length of copyright protection. But why not revisit and think about whether it makes sense?
Well, I did put the link to the request for comments on the green paper, and we'll go ahead and make green paper our second MCLE passphrase for this episode of This Week in Law. The request for comments is in our discussion points at delicious.com/thisweekinlaw/233 is the episode we're on. So you can check that out if you want to read the whole request for comment and the various questions that are being posed there. It definitely seems like every aspect, certainly the most important and controversial aspects of copyright law are on the table here. So as you were pointing out earlier, Art, it's good to be involved early on before things have started to take shape and take on a life of their own, where it's difficult to change them, and make sure that if there is reform in the works, that it's reform that makes sense. So folks should definitely go check that out. Question going back to getting involved early in the small claims copyright proposal. What was George Clinton doing there? Did he say anything? Did he weigh in? Did he bring Parliament with him? What happened?
Oh, gosh. I knew you were going to ask. I was only at the second day of the proceeding, and he showed up the first day, and I apparently I was told, though, he did talk a little bit about the importance of copyright to protect folks and encourage creativity, but somebody had mentioned that he did mention something also about sort of users and downstream users' rights, but I didn't get the detail of exactly what he said. I think his testimony is in the record, though, so if anybody wants to go look for it, it's absolutely there from the UCLA testimony that happened last year in the small claims proceeding.
All right. I will definitely go dig that up after the show and put it in the show notes as well. Okay. Really interesting stuff, all of this, and very important stuff. Let's take this down to a specific example of fair use that New Media Rights has been involved in, battling against one of the content holders in the entertainment field. All right, so there is a library. It's called the Lansdowne Library. And Lansdowne. What state is that in?
So they are actually in the Philadelphia area, and I believe it's in West Philadelphia, so I believe it's in Pennsylvania there.
There we go. And they came up with a great plan to get kids involved in the library. And have them make a video that would help other kids get involved in reading. And they made this hysterical and really creative video that I'm hoping we can play a bit of here in a minute. That is a parody of the Michael Jackson song, Beat It. And their theme was to read it. So here you have Michael Jackson's song about gang violence, etc., and the library is trying to send a similar message where we want to get kids off the street and get them doing something fun like reading. And so they I'm going to let the video speak for itself a bit if I can. Alex, if you're ready to roll that, let's do it. And if you're not, let's do it in a minute. So they read you some classic moments from the video. My particular favorite part is toward the end where people who like to read books are squaring off against the people who like to read on an e-reader. And they're, in the stacks of the library, bashing each other with iPads and things. It's really cute. And So, it did its job. It got kids involved. It got them interested in reading. But it has not had an easy time of it on YouTube. Tell us what's happened to their art.
Sure. I got that stuck in my head, though, all day. Whenever I hear that, that's it. It's going to be all weekend. It's going to be stuck in my head. Thank you.
Yep. Yes.
Okay. So after that was posted to YouTube about a year ago, Sony took down the video and claimed that the parody or that this video was copyright infringement. And so one of the librarians there, and I should say, this is a pretty tough neighborhood of Philadelphia. This is something where it's really important to get kids into a safe spot, to get them involved in something, to expose them to some of these technologies and things that they're not exposed to, the process of filmmaking. And so that's a piece of this story. And so once they got taken down from YouTube, the librarian from Lansdowne actually went down to Sony's offices, or I think went up to Sony's offices in New York, and basically
I see her in a very Michael Moore kind of frame of mind. She should have brought her documentary filmmaking crew and documented what happened.
Oh, she's wonderful. She's got the great Philly accent going and everything. And she really went there and tried to get some answers. And they tried to do everything they could to get the video back up. Actually, they tried to appeal back then. They made a YouTube video to protest the takedown, which you can also look at, which says something like Sony won't let Lansdowne kids read it or something like that. And they even went to Sony's offices in New York. And they were, Abby, the librarian, was asked to leave. But the director of the library wouldn't give up and eventually got a hold of Sony and was told that, we're not going to allow this video to go back up. It's a message video. It's not, we're not going to say that this is legitimate use. And so they consulted some lawyers at the time who told her, Sony's wrong and the video was indeed fair use. Sony kept refusing to put it up until the story goes that apparently it was going to appear, the story was going to appear on Good Morning America. And I guess there was a last minute check on this story with Sony. And I think at that point, they finally succumbed and decided, okay, we're going to let this video go back up. And they actually, at the time, had told the library, look, if anything happens in the future, don't go public first, just bring it to us and we'll help you take care of things. So about a year later, right, the video gets taken down again, but really the audio gets disabled this time, not necessarily the whole video taken down, but the audio is pretty critical piece. And so again, they did what Sony said, and they actually reached out directly to Sony, and it was the same representative, Jimmy Askey over there, and he basically said to them, look, there's nothing that we can do. We don't have control over that, even though it's their library of content. Yeah.
The phraseology he used, it's caught in the YouTube vortex.
Yeah, he not only said that it was caught in the YouTube vortex, but he said that that it's caught in the YouTube vortex, and if you can navigate the YouTube vortex, we'll give you a job at Sony, was actually the language he used. So I think that Abby should go call in that job and go ahead and follow that up maybe. But so, yeah, he actually said, look, it's this YouTube vortex. And from what I understand, the comment actually was that Sony had even had some trouble in the previous weeks with a Carly Simon record that they had put up some legitimate, I guess, video of their own and then had trouble with it working with the whole content takedown library and the content ID library. So he basically said, look, we can't do anything about this. And she said, well, maybe we'll go to the press again. And he said, well, that's old news and no one will be interested. And I bring all that up because this is one of those situations where the only thing that can be done in a lot of these situations, unless you bring a 512F claim, which is, really an option you really have to think carefully about. And you have to plan for what is the lens case is 6 years in, right? So you have to be ready for for a long drawn out fight. The other option you have, and it's really important for us in the media to make sure that folks know about these stories, that folks are actually told about these kind of takedown stories. And eventually we helped Abby navigate the appeals process and work with YouTube to get the video back up, and the video and the audio on the video is back up now. Yes. But I find it a bit ridiculous.
We could play it.
Yes, that's exactly. And yes. So I find it a bit ridiculous that it's so easy for companies like Sony to take down many, many, many videos a day via their Content ID system and choices that they make, but that when there's one error now and then, that it can't be recognized and fixed. And it's unacceptable for the copyright holders who have this great red carpet. They really have a red carpet at YouTube. Mm-hmm. I mean, they have a red carpet to go in there and claim content and put ads on it, or to take content down. And that's even easier than the average user's ability to take content down. And for that red carpet, it's kind of ridiculous that they don't also have, or that they claim they don't have, the ability to deal with the dolphins that get caught in the tuna net, say.
Yep. Mm-hmm. That's right up there with the sidewalk analogy. It's a good one.
Okay.
No, I think it worked.
I'm usually not a big analogizer, but today I got a couple, I guess.
And that was Professor Crawford's anyway.
Right.
All right. We do have some further resources and a tip for you. We'll do the tip first. The tip is sort of both macabre and lighthearted. Came to me on Twitter through one of our listeners there. I think Totally Fried on Twitter pointed me to this one, which is a family that attempted to do the right thing when they wanted to use SpongeBob as their headstone, a huge SpongeBob headstone for their female family member who was an Iraq War veteran. And apparently one huge SpongeBob headstone wasn't going to be enough for their family. She had a twin sister who also commissioned one. The twin sister's still alive, but I guess the thought was that they would be side by side. SpongeBob dressed in army attire. And they actually went to the step of getting copyright approval from Nickelodeon for each of these $13,000 headstones that the family purchased. So they thought they were all good to go. They'd actually cleared copyright, but our tip is that sometimes clearing copyright just isn't enough. The cemetery has decided that, whoops, we jumped the gun on giving you approval to use these large SpongeBob headstones, and that we're not actually going to let you go forward. So now the Walker family who commissioned these headstones, it looks like, may sue the cemetery because they were told that this was going to be just fine. So their lawsuit will proceed, even though they did all the right things on the copyright front, apparently. So if you are inclined to have a large cartoon character on your tombstone, be aware that there may be things other than copyright that come into play. Also, we have two more great resources of the week for you. Don't forget Susan Crawford's book, The Captive Audience. Also, over at New Media Rights, they've got legal guides, more than 150 legal guides for we just barely scratched the surface today in the show of the kinds of things that they can give you guidance and insight into. There's, a whole slew of things on copyright and fair use, various how-to guides. I really like all your guides, art on how you can find things to use in your creative works that you will know for sure are in the public domain or that you're licensed to use. So great resources there for creators, bunch of stuff on Creative Commons there, great guidelines for videographers, other things about sharing, the DMCA, free speech and censorship, cell phones. how to make your own cell phone ringtone for free and not get into any legal trouble, for example. Colette Vogel's Legal Guide to Podcasting is featured there as well. So there's just a slew of great resources on the page. It's a little bit long of a URL, but it is in our discussion points for this show. And if you just search for New Media Rights Legal Guides, you will find them. Really wonderful resources. Looks like you've spent some time on that, Art.
We have, and I think one of the things we're really proud of as well is that all those written guides are really written to creators themselves and internet users themselves. So, we're friendly with lawyers as well, but I think those are readable by not just attorneys and experts. I think those are readable by the people who actually need to make decisions based on information that they're finding. Also, we have over 150 video guides, which I'd highly recommend to folks. There's an extensive series for independent video game developers, some of which we work with quite a bit. We work with the modding communities as well as with independent game developers. There's also a basic copyright legal education series, which is just under 30 videos, and it only takes about an hour, 15 minutes to watch. So if someone's looking for a basic kind of primer in copyright or wants some basic questions about copyright answered in what I think is a really watchable format, particularly for a legal nonprofit, I think we've done pretty well to make those actually engaging and watchable. And they're only about 2 to 5 minutes. And I'd highly recommend the video guides as well.
And this is just so cool. It's in conjunction with the California Western School of Law in San Diego. And I just love it when law schools put their resources into such great community tools and applications. So that's just really great to see. And, so the next time you're shooting me an email or Evan an email on things that have come up in your life where you have questions and may need some legal help, definitely bookmark this. We're happy to hear from you too, but you may well find much better information over at New Media Rights lists of resources and also their video guides there. One other plug, I don't know if this is a resource or not, but I know that people who watch and listen to this show will love the current episode of Triangulation. Half the studio let me know that I needed to watch it if I hadn't seen it already. It's with Ladar Levison from LavaBit. Just went up on October 23rd. Leo interviews him, talks about the future of LavaBit, whether it will rise from the dead, and the whole sort of blow by blow of what happened to Ladar starting in May of this year when the FBI started knocking on his door, and the decisions that he had to make based on the request for information that he was receiving. So really, really interesting episode of Triangulation up there ready for you to check out. And I also, for those who are missing the puppy who joined us last week, Caramel, our new puppy, she is getting acquainted with the neighborhood dog sitter today. So she has not been downstairs crying for attention while I've been doing the show, which is a good thing. But if you're missing out on the cute, if you just haven't had quite enough cute in this episode of This Week in Law, I didn't want to end the show without letting you have your quota of that. And we're definitely well prepared to provide it for you this time around because our intern, Sanny Doe, has just been awesome. He's waiting for his bar results in November, and he's been so wonderful and helpful. I swear, I've emailed Professor Crawford myself probably a half dozen times since we originally started the show 7 years ago, and it's just never come together that she could be on. Sanny, got her just like that. So he's just been doing a bang up job getting guests. And he also, in the meantime, has managed to have his first daughter. So I think we have a photo of her that we can show. And even better, beyond just the fact that she's just scrumptious, is her name. She has the most deliciously geeky name of any child I've ever come across. Her name is Daenerys Swan Lando. So for anyone who's a Game of Thrones fan, she's got you covered. For anyone who's a Once Upon a Time fan, Emma Swan is in there. I'm told that's how you pronounce Xuan, which is her second name. And then the end of her name, Lan and Do, of course, gets your Star Wars fans in there too, with a small homage to Lando Calrissian, as well as other family members of theirs, I'm sure. So welcome to the world, Daenerys. We're thrilled for Sanny. And once again, thank you so much, Sanny, for the great work you've been doing for the show. We love having interns help us out. I'm hoping that Sanny will just decide to sign on for the foreseeable future, but we know that that's not very realistic. So if you are ever interested in helping out with the show, of course, that's one of the ways that we love to hear from you. I'm Denise at twit.tv. Evan Brown, who couldn't be with us here this week, but will be back soon, is Evan at twit.tv. So definitely hit us up with your voluntary contributions to the show. Whether, if you can't be an intern, just send us a link. If something catches your eye, you think it's interesting, let us know. This is how we put together the material for the show. If you come across someone quoted in an article who sounds intelligent and you want to hear more from them on the kinds of issues we talk about on the show, send us their name. We'd love to invite them on the show. What else should I tell you? You can also, if you're not an email person, you can find us on Twitter and on Facebook and on Google+. Love to hear from you there as well. Art, I understand this is not our first episode. We're on a roll here of new media rights folks, and we have your colleagues Terry and Sean joining us next week as well.
Absolutely. They are both wonderful. Sean is really responsible for those video guides. He's got this filmmaker background, and Sean left us in. He's on our board still, but he's actually off producing films, and he's in the creative world now. So you can actually ask him a bit about that. He has his feet in both worlds, the law and the creative world. And then Terry has a background working she worked at the EFF for a little while. She worked for the Federal Legal Assistance Self-Help Project. And she's just a copyright guru, and she is awesome. And you'll have a great time talking to them both. And I'm thrilled that Sando invited us for both weeks. We're glad to come on anytime. I'm a big fan of the show, period, and look forward to listening in the future. I really like the fact that you give folks a chance to not have to talk in sound bites. And so I love the discussion format, and I appreciate what you're doing here on This Week in Law.
Well, we really appreciate that. We're fans of yours too, and we know it's not easy to be down there in the trenches helping internet users and creators in the way that you do. And again, think it's just a wonderful thing that you're up to. I think one of the articles about the Read It video characterized you as a, two-lawyer shop, basically, definitely in need of help and support. So if you're the kind of person who donates to EFF, definitely get new media rights on your list as well, because they're out there doing very worthwhile things and advocacy and lawmaking potentially with some of the things we've discussed today. So thank you so much for joining us today. If you've watched us live, that means you have tuned in at 11 o'clock Pacific time. That's when we record the shows. That's 1800 UTC for those of you not in the Pacific time zone. We record the shows every Friday at that time. You can watch live with us, jump into IRC, give us your questions and thoughts and suggestions live as we record. That's always fun. If you can't do that, though, head on over to twit.tv/twill, and you'll get our archive of shows there. You can also find recent shows at youtube.com/thisweekinlaw. We're on iTunes. We're on the Roku. I love that we're on YouTube because so many TVs are just now sort of bundling that service in with what they offer. So we're in your living room or your portable device, wherever you would like to enjoy our show in audio or video form. We're going to be there for you. And we really appreciate your being there for us today and all the time, and for tuning in to This Week in Law. We've enjoyed ourselves, and we hope to see you next week. Take care.